Hearing, Circuit Court, Branch 33 in the Port Milwaukee County is now in session. The Honorable Lawrence C. Graham Jr. presiding. Silence is commanded. You may be seated.
Cross-examination, Mr. Boyer. You got to just come back. Doctor, you understand you continue under oath?
Yes. Yes, I do.
Morning, Pat.
Morning, Mr. Boyle.
I'm going to have defendants exhibit 27 and be a 10 PR, or whatever you should wish to have of it. Dr. Fosdal testified for 7 hours on Saturday, and I attempted to do is to go through your interviews to move us along quickly in cross-examination. If at any time you need to look at any of the notes, just let me know, okay?
Yes, I will.
Okay. Now, on the one easel in the back, I have put down 5 dates. I already got to pull this out. My belief that the 5 dates listed thereon represent the 5 occasions that you were with Jeffrey Dahmer. October the 16th, October 23rd, November the 13th, December the 20th, and January the 9th.
That's true.
When you first saw Jeffrey Dahmer on October the 16th at the place where you saw him, which I think was the Milwaukee County Jail, was it?
Milwaukee County Safety Building,
Okay.
right off this courtroom.
Did you have a copy of his confession? We call that 1A, Judge, isn't the confession as...
That, as I understand it, is marked as 1A. What we have actually received in evidence.
Did I have that? I'm going to show you what has been marked as defendant exhibit number 1A. I'm going to ask you at the time that you saw Jeffrey Dahmer, did you have defendant's exhibit 1A with you?
My recollection is that I did have his confession by that time.
Had you read it?
I had read most of it.
And you at any time asked him any questions in that interview of November the 16th, any specific facts relative to any of the homicides with which he was charged?
Not specifically, I don't recall.
Okay. You were with him 3 hours.
3.45, 3 hours, 45 minutes.
And you knew at the time that you talked to him, did you not make inquiry if he talked to any other doctors?
Pardon me?
You talked to him whether or not he had talked to any other doctors prior to talking to you?
That was mentioned, yes.
You knew that he had not talked to either Dr. Berlin, Dr. Beckram, or Dr. Wallstrom at that time?
Yes, I did.
You had no identity, you had no knowledge of the identity of who the defense experts were going to be or who the defense was going to summon in to talk to Jeffrey Dahmer at the time you first mentioned him, correct?
Just one doctor, that
Dr. who?
Smil,
He's a psychologist.
a psychologist.
Had you followed any of the proceedings of this matter prior to the time that you got there on October the 16th?
Just, well, I was called to come down here the day after he was brought in.
So you also knew that there was some question as to whether or not he was competent to proceed, and there were some statements in open court made by Dr. Smale that he examined him for the purposes of competency. You knew that, didn't you?
I heard that you and he were in court. I did not know that he had testified.
No, but did you know that there was some inquiry made into whether or not he was competent to proceed? You become aware that there was some psychological findings relative to that?
I heard it was mentioned and or declared that he was competent within maybe the next day or a couple days later.
And did you not know that at least at that time, the purpose of Dr. Smale was to address that issue? Do you know that or not?
No, I did not know that.
All right, when you say you saw him the next day, what next day are you talking about? When's the very first time you laid eyes on Jeffrey Dahmer?
Oh, that was on October 16th, but I was called on Wednesday morning. I assume he came in, he was arrested Tuesday night and brought in. And I was called Wednesday morning to see if I could come down to see him Wednesday afternoon.
The day after he was arrested?
That's right.
In July of 1991?
23rd, maybe? It was on a Wednesday.
So you were hired in July, the day after he was arrested by the state of Wisconsin, for whatever capacity they wish you to proceed in.
They said that Mr. Dahmer was willing to talk to me or somebody, and one of the assistant DAs, I'll be glad to give his name if you want, called me at my home where I was doing correcting reports, and is it at all possible to cancel out your afternoon and come down here? And I did.
Okay, did you write a report on that?
No, I came down here and I did not meet with Mr. Dahmer. I waited.
You were hired by the state at that time?
Well, I was retained by the state, right?
Sure, okay. What I tried to do over the weekend was go through your notes so that we can move it along quickly. So I'm sticking specifically to the notes that you read concerning your interview of October the 16th, in case you want to go to that, all right?
Okay.
He told you about his prior arrest. He told you, is that true?
True.
He told you that everything that he did was his fault. In other words, he wasn't blaming anybody but himself, correct?
Generally, yes.
Well, did he blame anybody other than himself?
No.
He told you he wasn't into suicide, correct?
Yes. Yes.
Told you about his drinking, fact that he was at the Paul, fact that he was leading a double life.
Yes.
Told you he'd seen Dr. Palermo one time.
Yes.
Told you that he had confessed and was trying to make amends to the families.
True.
You went into his past history about growing up, and the only thing, well, let me ask you this. You said that you had been following this, but you haven't been present in the courtroom. Were you watching some of the proceedings on television? Just so you know, I don't care that you were. I'm glad that you were. But is that how you were getting your information? Radio or television?
Well, of course, it was carried on the news in Madison, and it was in the newspaper, so I read the newspaper.
But you heard some of Dr. Becker's testimony, but yet you weren't.
Oh, you're saying after the arrest?
Oh, yes, sir. I mean, I'm talking about in preparation for your testimony yesterday or Saturday. You were asked the questions. If you heard Dr. Becker, if you heard, did you get that off of watching television?
Are you talking about what did I learn after the arrest? Before I started
Let me strike the question. Have you ever heard Dr. Becker testify?
I saw her on TV.
That's what I wanted.
For part, for what, first afternoon.
So you saw
Tuesday,
some of her,
Tuesday afternoon, I believe.
you saw some of her testimony.
Yes, I did.
Did you see Dr. Berlin's testimony the same way?
Yes, I did.
Did you see all of his or just some of his?
All of his, half of hers, and then radio in Madison the rest of the time.
On who?
Wednesday morning, the remainder of Dr. Becker, and then
Dr. Wallstrom?
Dr. Wallstrom
Is it?
on the radio, between commercials, of course.
Sure. Did you hear all of his?
Most of it.
Right. Now, having seen Becker on television, did you listen to the rest of her testimony on radio the next
I did.
So basically, as you came in here, you're pretty much aware of what the three of them said.
In general, yes.
And that would be very important for a doctor to come in and testify, because if they said something that would alter your opinion, you'd be duty bound to tell us, right?
That's true.
Sure. So I have no quarrel with you doing that. I just want to ask you whether or not you, on the basis of what you heard, Dr. Becker testified to relative to Jeffrey Dahmer's early life, did you learn anything that you did not know as a result of your discussions with Jeffrey Dahmer relative to his early life?
Yes, I did.
What did you learn?
Well, I would just say in general, she took the time to review his past life in some detail, gather some information that I didn't have. So it's a mixed input. She had some details I didn't have. I think I had some that she didn't have, that type thing.
Let me just short circuit it. You went to great extents to get as much information as you possibly could based upon your commitment to your profession to be able to render your opinion as to whether or not Jeffrey Dahmer was suffering from a mental disease, the result of which caused him to lack substantial capacity to either conform his conduct to requirements of law or appreciate the wrongfulness of his conduct, correct?
True.
Now, did you believe, after having talked to Jeffrey Dahmer on the 5 occasions that you talked to him, when he was rendering facts that he was giving to you, either voluntarily or in answer to your question, that he was basically truthful when you were talking to him?
Yes, in general, I found him to be a very cooperative and what I consider a very forthright historian. I tended to accept most of what he said.
All right. Can you tell us, as you sit here now, any single fact that Jeffrey Dahmer told you that you do not believe and the reason you do not believe it?
I think the only time that I questioned his accuracy was when he said he did not remember events in regard to his arrest, coming to the jail, that type thing. That was the first statement he made that kind of made me skeptical.
All right.
That seemed a little unusual. Otherwise, most everything else before that, I thought he was trying to give me a fairly forthright discussion. I think anything that might have been left out was either perhaps might not pushing him further on a specific point, and or he seemed to share very embarrassing information. If there was other things that were embarrassing that he didn't share, I don't know. But
Well, but for the most part, you think he was truthful?
yeah, he was about as cooperative a defendant as I've ever examined in 20 years.
And that means then that he wasn't making anything up as far as you were concerned, correct?
Well, that was my impression, yes.
In other words, he wasn't making up any false symptoms like some people you've run across where they say they were hearing voices and you didn't believe them?
No, he did not impress me as attempting to linger any type of symptoms or psychotic symptoms.
So did he tell you, were you surprised to hear that he told some of the doctors about this first fantasy he had concerning the jogger where he was going to hit him with the baseball bat, but he didn't tell you about that, did he?
No, that came during my last interview.
But isn't it safe to say that that really doesn't mean anything unless you see a pattern of somebody coming in with information, leaving information out, changing information around? That doesn't mean that he wasn't being candid with you because he left out anything about the jogger in his first interview. Am I correct when I say that?
No, I think what happened is that what you have to realize, there's an examination effect of people examining a defendant, and the first person to talk to somebody can often get a fresh account. Follow-up examiners may or may not benefit from the earlier examination. Sometimes defendants get talked out. Sometimes earlier examiners jog memories, and also I'm quite sure, based on my interview, a fair amount of the stuff was you're discussing something and the defendant learns from the discussion, gathers insight. Sometimes then this is shared with later examiners. I saw Mr. Dahmer after Dr. Dietz had seen him, and apparently Dr. Dietz had jogged some memories that Mr. Dahmer had not told me. For example, the school episode, the jogging episode, and the cemetery episode.
Sure. But you learned, did you not, that the jogging episode, the cemetery episode, and the school episode were told to the other doctors long before Dr. Dietz talked to Mr. Dahmer, correct?
I believe to Dr. Parker.
So to save
Becker, I'm sorry, Becker.
So to save us a lot of time,
Fine.
I don't have to go through all of the things that Jeffrey Dahmer said he did for you to tell me that you believed him when he said it, because for the most part, you believed that he was telling you the truth about everything he told you, except the part that you didn't really believe, that he couldn't remember the ride to the police station.
It's not that I didn't believe it. I'm just saying that's a little unusual. I'm not sure why he would not.
Sure. In other words, it seems kind of inconsistent that a guy would admit to all of these things and all the sex and all of the bad things, but would lie about the ride to the station, right?
Right. I thought we had very good rapport, and I appreciated his cooperation.
Let's assume that he wasn't telling, let's assume that he made that up. You're not suggesting for one moment that that would have been made up by someone who was trying to cause you to believe that he was delusional, would you?
I'm sorry, make up what?
Well, make up the fact that, hey, I just don't remember the ride to the police station. I can't remember that. That has no significance in your medical opinion, does it? Whether it's true or not true.
It's not a biggie, no.
Yeah. As a matter of fact, it's a real smallie.
Well, if he truly does not remember, then why doesn't he remember? And what choices do you have? Was he truly that intoxicated again that he did not remember? He certainly was drinking that day. He claimed that he, I may elaborate, somewhat blacked out in regards to the Edwards matter at the apartment, and that's how Edwards got away. And if that's really true, I guess what I interpret from that is that his own drinking problem led to his eventual arrest and his downfall.
Okay. Now you're attributing that to drinking problem, and I want to ask you some questions about that as we go along. But for the moment, did you hear the testimony of Dr. Palermo?
On the radio, yes.
And did you hear the discussion that he and I had about the significance of the DSM-3R?
I did.
And do you share that the DSM-3R is, well, strike that. That's not a fair question. Tell us what your, do you ever use the DSM-3R?
Sparingly.
Okay. Now, when you doctors report, you didn't report a number for your finding of necrophilia not otherwise specified, but it appears that, I beg your pardon.
Paraphilia, not otherwise specified.
Pardon?
Paraphilia, not otherwise specified.
You didn't report, you didn't report a number with that paraphilia.
No, I do not give numbers in my court work. I generally talk in more generic, plain English type of diagnostic formulations. I will tend to use diagnostic categories that, certainly conform with DSM-3R, but I don't get into compulsively trying to pigeonhole and use these labels.
Is the definition of a paraphilia as contained in DSM-3R one that you accept or reject or modify? Do you know what it is?
I think it's a confusing introductory page there. It's not very much I don't think it's in plain English, but no, I go along with the committee's formulation. That's fine. They're trying to make it.
Tell me what your definition of a paraphilia is, please.
Well, basically, you need a desire or interest. Your sexual orientation, your sexual desire, urge, interest is toward something, whether it be, objects like shoes or what have you, or in this case, whether or not corpse is the aim of your interest, that type of thing. So or children or window peeping or exposing yourself, that type. If this is really your sexual thing, I grew up with sexual deviation, as we used to call these, a type of sexual deviation. And just like Dr. Berlin said, they're used synonymously. So the plain English translation would be, I like the term sexual disorder. He has a sexual disorder, and if you want to get more technical about it, then you get into DSM-3R, and it's a paraphilia, which is an unusual word, but it's a technical word, and then you try to get more specific. In general, I don't, in this case, especially where we're dealing with one of a kind, we don't have a specific category for this. We have a category, well, I'll stop. Ram.
We know it's a paraphilia.
Yeah, what's one thing wrong with Jeffrey Dahmer, that chapter applies to one of the areas of disturbance of Jeffrey Dahmer, and that's his sexual adjustment.
Right now, you agree that Jeffrey Dahmer was having recurrent, intense sexual urges and sexually arousing fantasies?
Yes, he has sexual fantasies.
Do you agree that Jeffrey Dahmer was having recurrent, intense sexual urges and sexually arousing fantasies? You agree with that?
Yes.
Sure. And they involved non-human objects?
Depends on how you interpret that. My history did not suggest that he has been daydreaming about corpses. He certainly has homosexual fantasies and desires, and he was first of all a gay homosexual person, and then he starts, at least in adolescence, fantasizing and wishing and thinking and desiring the fully compatible person.
Okay.
And that's how things are.
So you agree that he was a paraphilic?
That he is sexually disordered, yes, which is paraphilia falls into the broader category of sexual disorder, and I'm more comfortable working at a higher level of generalization. So
Now, let's assume that a doctor, based upon his interview with Jeffrey Dahmer, just as you did, would say that I think, in my professional opinion, that Jeffrey Dahmer, amongst all the other things he was also necrophilic. Would you disagree with that?
well, as I listened to the defense examiners, there is mixed information as to his fantasy life. My information certainly was somewhat different than theirs. They obtained what I had in part, and also they obtained other information. So after hearing what they said, they supported the notion that perhaps there was more of a more pure necrophilic desires going on than he told me. So,
But he told you about his necrophilic desires.
he did not imply to me that over the years he has been lusting for corpses, which is a more pure necrophilic problem. Okay.
He is not, what you're saying is he is not an exclusive necrophilic, because he does things other than what a pure necrophilic would do. Isn't that true?
True. I do not believe that that's his primary sexual preference is necrophilia.
Did you hear the testimony of Dr. Becker, where she said that he wanted them comatose state and to have sex with them while they were in that state?
Right, in a passive, passed out state.
What is that paraphilia called?
Doesn't have a name. If you want to make one up, you can. But it's not otherwise specified, means sexual disordered in a general way, which includes, this is abnormal sexual behavior. You don't knock out your partners to molest them or have sex with them. That's sexually disordered behavior. You don't have to label that particular aspect. It falls under the general category of sexually disordered. So I don't have to get that specific about it.
I understand. I just want to know if you had a name for it. Now, there are other things that have names in the sexual disorder manual, and tell me whether or not you accept or reject these names as being part of paraphilia. Sexual sadism.
Right. That's a type of...
Was he a sexual sadist?
In my opinion, he was not.
Okay. There is exhibitionism. Other than the times that he admitted to them, to the exposing of himself, when he was with these young men that he killed, he wasn't doing any exhibitionism, was he?
No.
That you know of?
Well, he has a history of about a year's worth of exposing himself, so that's part of his history, which again reflects disturbance in the sexual realm. but he was not an ongoing chronic exhibitionist, and certainly it's not related to these crimes. It's related to the individual who committed the crimes.
Okay. How about fetishism? Do you think that he was into the sexual paraphilia fetishism?
Not as it's usually used as far as truly hoarding and collecting and, let's say, sexual apparel. And really, this is a strong goal of his, is to acquire this stuff, and this is how he spends much of his time achieving sexual satisfaction.
How about frodoism, that rubbing against somebody who's non-consent? Did he have that?
Well, he may have done it, but it's not his main goal.
He's not a pedophile, is he?
No, but in part, he certainly did have some proclivity toward younger people, and I think he had something in common with a pedophile or a pedophilic person. I might add that most pedophilic behavior is committed by people who are not pure pedophiles. He did have a certain definite age advantage over some of his victims, and seemingly a more mature man, an older man dealing with the younger person, you have that advantage. You're sort of one up on your victim, just like the sexually maladjusted man who molests a young girl.
If your book, DSM-3R, kind of indicates that this diagnosis should be made when there's this kind of conduct with youngsters 13 years or under, we don't have a history of Mr. Dahmer doing that, do we?
No.
Okay. How about masochism, sexual masochism?
Not there.
Not transvestic?
No.
Hyperactive sexual desire disorder or sexual aversion disorder, do we have that?
Well, he's certainly a hyperactive sexual person, yes.
The reason I'm asking you that is if I look at the book that you folks use, or at least is there for your use, where he fits in as a category of sexual disorders not otherwise specified, and that is because what he is all about is not easy to delineate by a term, correct?
Not a specific term, but if you move back up the organizational chart, he does fall under, of course, I think one of his primary area of disturbance is in the sexual functioning area in the chapter dealing with sexual disorders. So he's sexually disordered, but not, there's no specific category for this.
No, he's a paraphilic.
He's sexually disordered, which is even more, yeah, fine. That's a technical term. In plain English, he's sexually maladjusted, he's sexually disordered.
Now, is this a disorder of the mind?
It's a disorder of sexual behavior.
The disorder of the mind.
Well, I don't use the term mind.
Okay. Can it ever be a sexual disorder, not his sexual disorder, but a sexual disorder per se, in and of itself, ever be a mental illness? Without anything more, just a sexual disorder.
A sexual disorder is a disorder. It's a mental disorder. And which disorders are considered mental illnesses or diseases is a matter of interpretation, examiner variability. It's nowhere defined. Certain mental disorders, such as schizophrenia, almost every examiner would agree that that's a mental disease and a mental illness. Examiners may vary as to whether or not they would consider a sexually disordered person a mental disease. For this case, just to avoid that semantic argument and discussion, I am considering the nature of the case, the nature of his maladjustment. I have considered this a mental disease for legal purposes.
You consider it a mental disease?
For legal purposes, for this case, yes.
So if it's a mental disease, then it is your testimony to a psychiatric certainty that Jeffrey Dahmer, on each and every time that he committed these homicides, was suffering from a mental disease.
That's true. He had his sexual disorder prior to, during, and since that time.
Now, the definition then of whether or not a person is not responsible is whether or not at the time of the commission of a given offense, they were suffering from a mental disease. And if they had a mental disease, the question then is, as a result of that mental disease, did they lack substantial capacity to conform their conduct to the requirements of the law or appreciate the wrongfulness of their conduct? Do we agree on the legal definition?
We do.
Therefore, if I were to divide up the question, you want some water?
Please.
I thought you were toast.
No, we're not done yet.
You found the mental disease in the legal definition.
I don't know about the legal, I mean, the standard for non-responsibility, I am calling Mr. Dahmer has 3 areas I would consider of psychiatric disturbance. One of them being he's sexually disordered. I am considering that a psychiatric disorder as far as this case is, well, it is a psychiatric disorder. I'm considering it a mental disease in regard to the standard for non-responsibility, that he needed a mental disease to as a first prong of the test.
Okay, now.
It's a 3-prong test.
So the first prong of the test is whether he had a mental disease,
Right,
and you
and
said yes.
I'm conceding that he does. I think I'm considering his behavior mentally disordered / mentally diseased.
Now, the next part of the question then is whether or not he could appreciate the wrongfulness of his conduct or conform his conduct to requirements of law as the other 2 prongs with the concept of substantial capacity, which is really the key, correct? That's the other 2 prongs, right?
Yeah, the second prong is wrongfulness, and third prong is conformity.
Now, if you found that Jeffrey Dahmer, when he was suffering from this mental disease, was also schizophrenic, in addition to the mental disease that you opined, would he then be able to have appreciated the wrongfulness of his conduct when he was doing it? If he was schizophrenic when he was doing it?
You're saying if he was a schizophrenic who also was sexually disordered?
Yes.
If it's object, there's absolutely no evidence of schizophrenia that I'm aware of.
The whole hour and a half was talked about why he wasn't schizophrenic. I know there isn't. I'm going to ask a question because I want to assume that he was schizophrenic. Besides having a mental disease, how would that have affected his appreciation of whether or not he could understand the difference between right and wrong? I'm allowed to go into this inquiry because
No.
Sorry.
Well, I'll decide what's allowed and what's not allowed.
Yes, Judge.
Objection's overruled.
I would like to know that if, in addition to the mental disease that you told us Jeffrey Dahmer was suffering from, if during the time of the commission of these homicides, he was schizophrenic, that is, having a schizophrenic episode, would he then have lacked substantial capacity to appreciate the wrongfulness of his conduct?
You need more information on that. You can be schizophrenic and still appreciate the wrongfulness of what you're doing. You can be schizophrenic and still be able to conform your conduct. You have to decide on each individual case. Sometimes the schizophrenia has nothing to do with the crime. Sometimes the crime is a clear reflection of the person's schizophrenic illness. And that's the role of the examiners to decide what's going on here.
So it doesn't matter absolutely that one was a schizophrenic or not when you delve into the other 2 prongs. In other words, if you take someone who has simply the mental disease that you're talking about that Jeffrey Dahmer suffered from, he could still lack substantial capacity to appreciate the wrongfulness of his conduct.
Objection.
Now let me rephrase it. It has been pretty much the issue here that we are on the conforming conduct to the requirements of the law. You're aware of that from hearing all of the testimony, correct?
So far, everybody has agreed to, well, everybody that I've heard is calling his sexual disorder a mental disease. Everybody I've heard so far is agreeing that he did not lack substantial capacity to appreciate the wrongfulness of his conduct. I guess so it boils down to whether or not he lacks substantial capacity to conform.
Without any other sexual disorder than the one that you have opined, that you say was a mental disease and was affecting Mr. Dahmer each and every time he committed one of these homicides, without anything more than that mental disease that you've told us about, was Mr. Dahmer capable in each and every one of those situations of conforming his conduct to the requirements of law?
Well, I do have an opinion on that.
And the opinion is
Well, my
what?
opinion is that this type of disorder, in and by itself, and also based on the individual examination, meaning an assessment of the case, but this type of disorder, in and by itself, in my interpretation, does not usually cause the degree of impairment required to meet the standard for non-responsibility. These people, an uncomplicated child molester, or in this case, an uncomplicated, well, he is complicated, without any schizophrenia or something. We're just talking of kind of a straight sexually disordered person, not, he's also an alcoholic and he has personality issues. This type of disorder, in and by itself, in my experience and in my opinion, does not cause the degree of mental impairment such as to cause them to lack substantial capacity for prongs 2 and 3. But so be it, you still evaluate every case.
Have you ever found in all these hundreds and hundreds and hundreds of cases that you've been involved in and people that you have ever examined, a person who had a mental disorder such as paraphilia, who was suffering from a mental disease as a result of that, as you have opined here, who could not conform their conduct to the requirements of law? Have you ever found one?
The only time in my experience, again, the paraphilia is a mental disease. You
I understand it.
You said that because he's paraphilic, it caused a mental disease?
No, you said that what Dahmer had was a mental disease.
Right. I'm calling his paraphilia a mental disease.
That's right.
Okay.
Now, have you ever run across anyone in your entire career, and all these thousands of cases that you've been involved in, hundreds, whatever they are, where that paraphilic disorder, as you have opined it in Mr. Dahmer, was such that the person was not able to conform their conduct to the requirements of law?
Again, if the person had another type of illness, but we rule that out.
Ruling it out.
The child molesters, the paraphilics who have been found mentally non-responsible, it was usually due to another type of mental disease. The only times in my experience that let's say, uncomplicated or a simply sexually disordered person was ever rendered mentally non-responsible was based on a stipulation for dispositional purposes, that this person's been tried in every other channel. And I'm thinking in particular just an amazing exhibitionist in the state who's been probably convicted in every county in the state and been on probation and parole. He had never been gone through mental non-responsibility channels and a mental non-responsibility commitment. And it was agreed, what else can we do with this person? There's no place else for him to go. Let's at least let him serve his time in a mental facility, which was my recommendation. Similar recommendations I have recommended in very sexually maladjusted people, since we no longer have a sex crimes program in the state. For dispositional purposes, you could consider managing him under a mental non-responsible commitment. And this has been done on several occasions over the years. Not commonly, but several.
And that's playing the role of Solomon. But I want to know about this fella that's exposed himself in every county in the state of Wisconsin. Was he suffering from a mental disease?
He was suffering from the paraphilia of exhibitionism.
did he lack substantial capacity to conform his conduct to requirements of law as a result of that mental disease?
Strictly speaking, he did not.
He did not.
He did not.
So what your answer is that you have never run across a situation where a person had a mental disease that was a sexual disorder that was so erosive that he lacked substantial capacity to conform his conduct to requirements of law.
Not solely based on that diagnosis, Tom.
So what you would have to find then is something else that would cause you to believe that not only was he suffering from a disease, mental disease of a sexual disorder, paraphilic mental disease, but there was some other kind of mental disease or some other kind of mental problem there besides, correct?
Or that he doesn't necessarily have a sexual disorder, but he might be schizophrenic and have been molesting children for schizophrenic reasons, or engaging in other aberrant sexual behavior due to a other type of mental disease.
Let's keep it to the Dahmer situation.
Fine.
He doesn't have anything other as far as psychoses. You've already ruled those out, didn't you?
Yeah, he does not have an ongoing psychotic disorder. He has alcoholism, and which is another chapter in the book. And his third area of disturbance relates to his personality makeup.
But none of those other two could ever combine to make that mental disease that you've already found such that he wouldn't be able to conform his conduct to the requirements of law, correct?
Right. His personality disorder, his personality makeup, as unhealthy as it might be, that in and by itself does not cause the required degree of mental impairment, in my opinion, to cause him to lack substantial capacity to appreciate the wrongfulness or to lack substantial capacity to be able to conform. His alcoholism is also, there's a chapter in the book on alcoholism. That's the second area that applies to him. That, being an alcoholic in and by itself, does not cause you to lack substantial capacity. The third area is his sexual disorder, and I'm considering that a mental disease. And then that disorder in and by itself, in my opinion, does not cause him to lack substantial capacity.
If I lined up 5 psychiatrists and 3 of them said, all 5 of them said, sexual disorders, Dr. Fosdal, in and of themselves, within the paraphilic concept, can be such that the person suffering from them can lack substantial capacity to conform their conduct to requirements of law because of that paraphilic disorder. You would say you don't agree with that and you never saw it, correct?
Object to that. No evidence suggesting that. It's unfounded as a matter of law. Evidence in this proceeding.
You have the question read back, please.
Question. Kind of 5 psychiatrists, and 3 of them said, all 5 of them said, sexual disorders, Dr. Fosdal, in and of themselves within the paraphilic concept can be such that the person suffering from them can lack substantial capacity to conform their conduct to the requirements of law because of that paraphilic disorder. You would say you don't agree with that and you never saw it, correct?
Why is that not appropriate?
I don't think it's relevant. Objection is sustained.
The court says it's irrelevant.
That's right.
Dr. Fosdal, assume that a person is a pure necrophiliac. By that I mean that he has no other desire than to have sex with a dead corpse. Make that assumption. Assume that that person finds a occupation where that object can be achieved. That is, his pure necrophilia can be achieved anytime he wishes it to take place. Okay? Assume he does it on 100 occasions, once a week, every Saturday night. All right?
Okay.
Assume that his necrophilia, in your professional opinion, is a paraphilia and is a mental disease. Accept that.
Okay.
Is it your testimony that without something more in the way of mental disturbance, that person would always be able to conform their conduct to requirements of law, and that is by not engaging in the illegal act of having sex with a dead corpse?
Objection again, assumes facts not in evidence. It's not relevant. It's irrelevant to this proceeding.
Sustained.
May I have a sidebar with the court?
No, we'll do it on the record.
Okay.
Proceeding chambers.
Your Honor, the court was kind enough to give me a few moments to put together my argument. I'd like to make an offer of proof. My offer of proof is that allowed to continue to cross-examine Dr. Fosdal, and if I were allowed to ask him certain hypothetical questions, it would become clear that his answers would be that a paraphilic disorder, which it becomes or is a mental disease, under no circumstances could ever be such, no matter how much control or lack of control the person who is the subject matter of the paraphilic disorder could ever rise to the level where that person would lack substantial capacity to conform his conduct to the requirements of law in carrying out the object of his paraphilic disorder. In order to do that, I asked a hypothetical, assuming that a person, and the hypothetical basically would have said was a pure necrophilia, and he was carrying on his necrophilic acts every Saturday night and going about the business of doing A, B, C, and D in order to do that, making sure nobody was there, making sure the doors were locked, making sure the lights were out. I'm sorry. Could that person ever be found by you, doctor, to, under any circumstances, without other mental aberrations, be suffering from a mental disease to the point where he was unable to conform his conduct to the requirements of law? It was at that time an objection was made. We went into chambers. That's history, what was in there. The press was in attendance. You were kind enough to give me some time to look up some cases. I specifically went and found two, and I would like, for the purposes of my offer of proof, to state the same.
Only one case is, the court has only been provided with the citation to one of the cases.
Okay, the other one would be Simpson versus State, Your Honor, 32 Wisconsin 2nd.
I would like to have a chance to look at it, Mr.
Sure, I understand.
Okay. You can go ahead. Finish the citation.
Sure. 32 Wisconsin 2nd at page 197, at page 207. That is cited in State versus Wright, 38 Wisconsin 2nd, 344. I would like to read, if I may, the quotation in Rice at page 353, citing Simpson versus State at page 206, quote, "There is a further rule that great liberty," and I'll give you this in case I talk too fast, "great liberty and latitude are allowed in the cross-examination of expert witnesses. However, the applications in this rule are often directed to such matters as the education of the expert, his practical experience, the extent of his observations outside his own work, as well as other cognate matters bearing directly on his ability as an expert. Upon such examination, hypothetical questions may go outside the record for the purpose of testing the skill of the witness. A hypothetical question put to an expert witness on cross-examination." Now, this isn't citing, this is the law in Rice. This is not citing Simpson. Hypothetical question put to an expert witness on cross-examination, however, need not be limited in purpose to testing the skill of the witness. The opinion of the expert on direct examination by the prosecution is certainly subject to attack on cross-examination by assuming different facts than proposed by the prosecution, not only to test the skill and knowledge of the expert, but to help the jury in determining the weight it should accord to the expert's opinion. It goes on to say, then citing Simpson again, or some other case again, "When it comes to cross-examination of such expert witnesses, however, the rule is not so limited, and within the field of the trial court's reasonable discretions, questions may properly be framed, assuming quite a different state of facts than those appearing in the record, for the purpose of testing the knowledge and the skill of such witness, and highlighted or underlined, and the weight to be given to his testimony. Now the highlight is now back to normal again. It says that an undue limitation of such right of cross-examination may be prejudicial error, is pointed out, and then they cite the cases where that was the situation. Very briefly, furthermore, in Simpson versus State, it says, there is a further rule that great liberty and latitude are allowed in cross-examination of expert witnesses. And then there's some more verbiage, and then the part I want to cite on page 206 of Simpson versus State. Upon such examination, hypothetical questions may go outside the record for the purposes of testing the skill of the witness. In the instant cross-examination, it is clear that the defendant's counsel was not directing his attack on the qualifications or the ability of a psychiatrist or expert, was seeking to support his hypothesis that a frenzy was the reason. Certainly, I'm not doing that here. I'm not trying to support any hypothesis. It goes on to say in the next page, at page 207, the right of cross-examination of psychiatric expert witnesses is subject to some discretionary control by the trial court. The trial court's reason given for the ruling that the longest of the propounded hypothetical questions was objectionable as to form because some facts and evidence were not included was erroneous. I know that rule, so I don't want to get into that. Here is what I am saying. I am saying that in this case, it is appropriate for me to be able to ask this doctor the question as to whether or not any paraphilic disorder, such as pure necrophilia, could ever be such that the person exercising it in the fashion in which I asked in the hypothetical question could be found not to be able to conform his conduct to the requirements of the law. And the reason for that is that for a great part of the 7 hours on Saturday, all we kept on hearing was, well, he didn't get a guy with a car. It was only when he wasn't working. It was always at night. It was always this. It was always that. I want to find out if the converse is true. I want to find out if all of those things were true for 1,000 times squared. Are they dispositive of the question that a person suffering from the paraphilic disorder that either Dahmer was or a pure paraphilic necrophiliac is out of the ball game simply because of that? And if that's his answer, then I think that goes to the weight and the skill of Dr. Fosdal that the jury is entitled to weigh in rendering their opinion. My offer of proof then is that I be allowed to ask Dr. Fosdal certain questions because it is my belief that he has a mindset that unless you have something other than a paraphilic disorder, in spite of the fact that paraphilic disorder can be a mental disease, you will always be held responsible because that will never be such that you will lose substantial capacity to conform your conduct to requirements of law. And I think the only way I can address that is in the manner and form in which I'm trying, and that goes to his knowledge and his skill and his prejudice as to whether or not that's his mindset. Thank you.
Mr. McCann.
To please the court, we've addressed the issue on the hypothetical, and I think counsel has called to the court's attention material the court will have to consider. And it's clear that the thrust of the hypothetical goes beyond simply assuming the facts of this case. I think the court also has to consider the relevancy in terms of confusion of issues to the jury. The issue in this case is homicide. It is not part of the paraphilia. There is no evidence that it's part of the paraphilia. We have not argued, although some may have argued this part of the paraphilia. This issue doesn't go to that. It goes to simply having the relations with the body, with the dead body, the example that's being provided. If it please the court, in my opinion, it poses the potential for confusing the jury as to what the issue is before the court. If he embraces in the issue that the morgue attendant kills somebody first to get the body, not that he does it 100 times, that he's done it 17 times, not that he does it every Saturday, that he does it over a period of a number of years, then it may become relevant. But if it please the court, under the posing of the issue presently can only confuse, has nothing to do with killing, has strictly to do with dead bodies, and the issue before this court is the killing, not what was done with the bodies afterwards. And in my opinion, as posed, it's subject to, in terms of confusion of issues, under 90403, that becomes a very real possibility.
I have no response, Your Honor.
Okay. The court would like to refer to State v. Rice, the citation for which has already been provided by Mr. Boyle. Page 356, starting about the middle of that page. In discussing the use of the hypothetical question, Professor Charles T. McCormick points out that courts should not be unduly restrictive in the formulation of the hypothetical. And then picks up a quote from McCormick. Direct testimony supporting the fact assumed is not required. It is sufficient if it is fairly inferable from the circumstances proved. Moreover, the supporting evidence need not have been already adduced if the interrogating counsel gives assurance that it will be. And of course, it is no objection that the supporting evidence is controverted. The proponent is entitled to put his side of the case to the witness for his opinion. That's the language in McCormick that the court relied upon in State v. Rice. Wharton's criminal evidence, section 600. States, an expert witness may be asked for his opinion upon the basis of a hypothetical statement of facts. The facts of a hypothetical question must already be in evidence or be inferable therefrom. In no event is it necessary that the relevant facts and evidence be repeated in the question verbatim. In section 601, it talks about cross-examination, where it states great latitude is allowed in the cross-examination of an expert witness. He may be asked any question which reveals the basis for his opinion or which challenges his expertise, and he may be asked whether he had been paid a special fee to testify. Our standard instruction on hypothetical question, which I've previously read, instructs the jury to determine whether the various items in the hypothetical have been proven, and if they have not been proven, to completely disregard the opinion of the expert. That's the general tenor of that instruction. I think what Mr. Boyle is pointing out to the court is that the court, in many evidentiary questions, has the right to exercise discretion. It's not bound by strict rules. In direct examination, a leading question may be asked, and if the court in its discretion thinks it's appropriate, the court can allow that leading question, even though normally it's objectionable. Mr. Boyle is suggesting to the court that when testing the credentials of a expert witness, that some hypotheticals can be asked under some circumstances that are not proved by the evidence. Or in this case, we're talking about hypotheticals which, in my judgment, in some of the facts are closely related to the evidence that's come in the case. And then we're mixing in some facts that have not been proven and will not be proven to the best of the court's knowledge. I think that becomes confusing to the jury. Now, what I have to do is I have to balance. That's what discretion is all about. Now, Mr. Boyle has suggested that there's authority which he has not yet produced to the court, but that's because some of the old cases aren't available readily in the courtroom, that the court should assist counsel in formulating the questions that would be proper, because what I've stated previously is that it's the hypothetical that the court is sustaining the objection to and is not prohibiting Mr. Boyle from asking questions in accordance with the offer of proof that he's just made. And Mr. Boyle, I would suggest that you yourself have formulated the questions. And if you have a problem with it, I think we can assist you in terms of getting a transcript of your offer of proof. And if you were to read that offer of proof, I think you will find that the appropriate questions lie within that offer of proof, which can be asked in a form other than a hypothetical question. For all of those reasons, the court is sustaining the state's objection.
In the necessity of having to always cover one's offer of proof so one is not criticized for not having made a statement and taking into account that it is bad practice to argue with judges, and I try not to do with that, I would suggest that the court, as I was accused of by one of the witnesses of mixing apples and oranges, is mixing apples and oranges in its reliance upon what McCormick said. For this reason, Your Honor, I am not asking this hypothetical question for the purposes of anything to do with the facts before this jury, except as they relate to the weight of the person delivering the opinion on whether or not he should be listened to because he has a closed mindset to the issue before the jury, and that is whether or not a person who is suffering from a mental disease can ever lack substantial capacity when they are suffering from this mental disease. If he were the judge of this case and the court moved for a directed verdict, the state moved for a directed verdict, Judge Fosdal say, case dismissed because no one can ever be found non-responsible when this is the only mental disease they have. And I think I can look into that because I think that's a real issue for this jury. Thank you for allowing me to say what I just said.
And I very briefly be heard. That isn't the issue. He isn't on trial for sex with the dead bodies. Fosdal clearly would, if the charge were dismembering bodies, that might, what Mr. Boyle suggests may be the case, but that isn't what the charge is here. One further point, if it please the court. Mr. Boyle asked some flat questions, straight questions on this issue. The state did not object to them. This is what I think now is a confusing hypothetical flowing from the direct questions that we did not object to. And I agree with the court. I think the ruling is proper that this will confuse. The court hasn't foreclosed the questions. I didn't object to the questions. I objected when a confusing hypothetical was raised.
Well, so we save a lot of time. My next question is, assuming everything you know about Jeffrey Dahmer, including the homicides, is there any way that his mental disease could ever be found by you without other evidence of mental disorder to be sufficient that he would lack substantial capacity to conform his conduct requirements to law? And that's what I was driving at, but I don't want this poor jury bouncing in and out. So let me try it another way. I understand the court's ruling. I'm ready to go. Thank you.
Well, since everybody had a chance to comment on the court's ruling, the court will comment on the attorney's responding. You know, it's good many years ago now, but I had an attorney in court. I won't say who it was, but it's a name that would be very familiar, at least to both of you gentlemen, who every time the court made a ruling had to respond to the court's ruling. And I finally told him, stating his name, which I will not repeat now, I said, you know, it's the lawyer's function to argue to the court, not with the court. Right. He then told me he didn't understand the difference, and I said my response to him was that I understood that he didn't understand the difference, but I trust counsel here understands the difference. Mr. Boyle, let's get the jury out here and we can proceed, okay?